While we await an indictment out of Georgia related to Donald Trump's efforts to overturn the results of the 2020 election in that state, there is new reporting out today about what that indictment might actually include. Today, The Guardian newspaper is reporting that Fulton County DA Fani Willis has in recent weeks weighed potential statutes under which to charge Trump. And they are solicitation to commit election fraud, conspiracy to commit election fraud, solicitation to destroy ballots, and solicitation of a public officer to fail to perform duties. Now, an example of soliciting a public officer to fail to perform duties could be President Trump calling the Georgia Secretary of State, Brad Raffensperger, and asking Mr. Raffensperger to find 11,780 votes so that Trump could win the state. Experts also think the former president could have legal exposure under the conspiracy statute for the steps that his campaign took to replace the state's legitimate electors with 16 fake Trump electors. Still with me is Andrew Weissmann, former Justice Department prosecutor, and joining us now is Michael Moore, former U.S. attorney for the Middle District of Georgia and a partner with the Moore Hall in Atlanta. Michael, let me start with you in terms of the words solicitation and conspiracy sound alarming. What do you make of these potential statutes and how difficult or how uphill a battle Fani Willis will have in court to try and prove them?
Well, it's a pleasure to be with both of you. The charges that they're looking at here are sort of bread and butter charges for prosecutors. And a conspiracy charge is a fairly simple thing to explain, and that is that it's just an agreement between two or more people to do something wrong here, and they have to take some overt act or some step in furtherance of doing that. And so that can be as simple as having phone calls or sending emails about setting up the fake electors. That can be, having people on the line saying we're going to pressure the Secretary of State to do something as it accounts to the ballot. So that's fairly simple. And the solicitation is just asking somebody to do something. So in this case, there's a question whether or not the phone call will be sufficient evidence to show that he was asking Brad Raffensperger to do something wrong, or was he asking people to go in and take voting machines or data out of certain registrar's offices. And so if you just think about this, you got to have there's an issue of an agreement, and there's an issue of whether or not he's asked somebody to do something. And so I think she'll have the evidence there to put that forward. And, obviously we're at the beginning stages of the race with whatever charges she comes out with, and they'll have to prove their case at that time to all the jurors. But nonetheless, something I think that there seems to be at least some evidence for her to get an indictment from the grand jury here.
Yeah, Andrew, the phone call seems to be critical here. I mean, there's the request to find 11,780 ballots that Trump makes to Raffensperger, but he also threatens him with criminal prosecution. I don't think we have time to play that entire piece of sound, but just the notion that the President of the United States is threatening the Secretary of State on the telephone with prosecution, is that sufficient? I mean, do you think that there's any sort of wiggle room on a phone call like that?
Alex, I'm really happy that you're focusing on that part of the tape, because I think if you put those two pieces together, the find the votes, the fact that Brad Raffensperger says, but there is no fraud, we've checked, there's nothing there, and then you have the then sitting President of the United States, not very subtly, saying, it would be terrible if you found yourself at the other end of an indictment because of what you're doing. Now, Brad Raffensperger wasn't committing any crime at all. I mean, even if you thought he was wrong, it is not a crime to be wrong. So the idea that he was threatened with criminal prosecution by the President of the United States, I think that is one that, because there will be obviously some additional evidence, I think that goes a really long way with a jury. That is not normal behavior. Even if you thought that you had won the election, that is not how you behave, and it goes a long way to understanding this was a way of extorting a state officer to not do his duty.
Yeah, well, and as both of you have pointed out, Michael, you just mentioned that solicitation doesn't mean that the other person has to carry through with the request, right? I mean, because when we're talking about the solicitation to destroy ballots, I can only assume that is when, again, President Trump calls Georgia officials and asks them to conduct signature verification going back 2 years, which is a much longer window than they are supposed to. Does that qualify as solicitation to destroy ballots?
It does. I mean, think of it just let's take a non-election example. I mean, let's say somebody wants to kill their girlfriend or boyfriend, and they pick up the phone and call somebody who happens to be an undercover FBI agent and says, hey, I want to pay you to kill this person at the diner on some night. You don't have to go through with the murder to be charged with the asking or the seeking, the solicitation to do it. And so that's essentially what you've got here. And I think Andrew's right. Part of that tape that is so compelling is the issue of whether or not the sitting president at the time, is threatening the sitting Secretary of State with some criminal problem if he doesn't do it. I mean, that I think is going to be a huge issue. That's just like a recorded confession that's been in the DA's hands for this long period of time. So, I think the evidence is going to be significant. I think there will be more motions and appeals and everything else than we've ever seen in a case like this, or there is no case like this. But the evidence, if we just talk about the evidence and what the DA may need to move forward to get an indictment, I think it's been laid in front of her for a long time.
Yeah, Andrew, in terms of the actual charges, like we know about these individual statutes, but when we've been talking about Fani Willis, the thing that often follows her name is the word RICO and or racketeering. Do you think that, I mean, if you're looking at this case, is your expectation that these are going to be individual charges, or does this fold into a broader RICO racketeering case?
I think we could end up seeing both. This is one where you can have a sort of overarching RICO charge, and we know that Fani Willis has had some success at bringing those kinds of cases, but that doesn't preclude her from also bringing these individual charges, and so a jury would have all of that in front of them. And so I kind of suspect that's what we're going to see, because it's really not an either or. We can see both of those, and it's a way of also with a RICO really being able to bring in a wide range of evidence to fully explain exactly what happened. And then you can have individual charges that are predicated on specific conversations, on a specific tape recording and specific conduct. But then you have this overarching charge to lay out just the full scope of what she is alleging.